Justice Correspondent Candace Kelley. She is here with us once again this morning. Good morning, Candace.
Good
Let's talk
morning,
about
Mike.
this case some and the reason why good morning to you. There's a reason why it's been delayed because of what you heard Dre talking about, some of the demonstrators out there. Apparently, the judge took issue with a John Lewis banner outside of the courthouse and then some other signs that were there, but as well as buttons worn by some in the court. What did he decide about those?
Well, he ultimately decided that this John Lewis banner that said "Make Good Trouble," as well as buttons that people were wearing inside of the courthouse, and as well as things that people were wearing that kind of showed other organizations that supported the Ahmaud Arbery cause and rallies. He said that inside of the courthouse, that was not allowed. Outside of the courthouse, so far, he allowed the banners of John Lewis to stand, as well as there was a young girl that was riding around in a fake motorcycle, holding up a sign that said, justice for Ahmaud Arbery. The defense counsel brought that up. They thought that that was an issue. So what was going on outside of the courthouse made its way inside, but the judge allowed what's going on the outside to stay, and he didn't touch that at all.
Yeah, well, look, the defense is going to do anything they can to help their defendants. I understand that, but how can that be an influence? We see these in these type of, especially racially charged cases throughout this country, where we see protesters or we see demonstrators and we see counter demonstrators. So how could that influence potential jurors?
Well, Mike, like you said, the defense counsel is going to do whatever it can to try to shift the focus of the case in any way to make sure that their defense gets justice, or maybe perhaps they are leading to this whole idea that they might want to change the location of this particular case. So what happens is that when people walk in, the defense walks in, if they feel in any way that they are intimidated or that somebody is putting them in a light that they don't necessarily
Hmm.
think they should be put in, that might affect what a potential juror might think, that can be an issue. And so that's why defense counsel Mike brought this to the attention of the judge, who ultimately made the decision that once again, these are peaceful protesters expressing their First Amendment right on the outside. Mike, they're okay.
Okay. All right, let's talk about the jurors. So day 4, still nobody's seated yet, but then there's no panic because I found out yesterday that it's not about the 12 and the 4 alternates right now. It's about the magic number of 64 because they got to go through
Yes.
phases, I understand, in Georgia. So how many people have actually gotten to that phase where they're being questioned one-on-one?
As you said, a group questioning, that's what happened at first. They've narrowed it down, 23 people. It's not, court is not in session today, but so far, 23 people. We're looking at that number for Monday in terms of where we're starting off. And as you said, the magic number is 65. The judge has determined that that's the number of people that need to move on to the next stage, so that once those peremptory challenges and strikes and people are kind of knocked off the jury, he says that that's the number that's needed in order for there to be at least 12 people left, with 4 alternates for a total of 16. So as you said, 64 is that number. Right now, they're at 23, Mike.
Okay, so about a third of them right now. All right, so a few
Yeah,
people
you do the math.
who were questioned said they actually, yeah, it's Friday, it's late, it's early in the morning too, so I'm trying to do it right now. But I do know that, look, this is a well-known case. It's been over a year and a half since obviously he was murdered, he was killed on that street that day. A few people who were questioned said they actually looked up the case online and were able to access some like crucial information about Arbery and the defendants. In your legal opinion, why is this problematic?
This is very problematic on the one hand, but on the other hand, if you do the right questioning of the jury, it may not be problematic because you have information that's out there that is and was public record, about Ahmaud Arbery's mental health, about the fact that he did have THC in his system at the time, during when he died. Now, that's none of that's going to make it into the court, but there were a couple of jurors who said during questioning that when they found out that they were called to be potential jurors for this case, they went online and they started to do a little Google search, and they got to these hyperlinks through the courthouse that connected them to these records, not just about Arbery, but about the defendants. So all this information was out there. Now, since then, those links have been removed. And some of those jurors who did actually see that information, they did move on because they said that information would not affect how they would judge the evidence in this case. But that's really important because you don't want to expose jurors to information that could get
Right.
in the way of their decision-making process. So the fact that this information was out there for over a year and a half now, as you said, was really interesting. But there was something that was put to a halt, and nobody can look it up online right now.
Well, you got to find 12 that are fair and not biased, and 4
Yeah,
alternates. We'll see if they can get it done. They got about a week and a half, maybe even 2 weeks before they actually start the
indeed,
opening
Mike.
or arguments in this trial here. But real quick, I got to ask you because this is trying to find these jurors. I understand they got over 1,000 potential jurors that they're bringing in to actually question right now. But in a small town like this, I understand it's not a big town, it's not a small town, but it's not like Minneapolis. It's not a major city
Right.
where if there's a murder or there's something that happens on the streets or whatever, people may not even notice it. Something happens in New York, something happens in Minneapolis, even in Atlanta, somebody might like, okay, that was in the news, it happened but nobody's paying attention to it. In this city or in this small town, everybody in that town probably has heard at least 75% of the story when it comes to what happened on that fateful day. So just because they haven't moved the venue, just how much more difficult does that make it?
Listen, the attorneys really have to kind of lower their threshold. In other words, if you do happen to know the defendant or the defendant was over your house at some time, like we've heard some of the jurors talk about, well, that doesn't make a difference. Now, in other cases, in a bigger city, that might make a difference because you have a bigger jury pool and a bigger town or city, as you said. Here with 85,000 people, the attorneys, and this is what attorneys do, they have to shift their threshold a little bit. That if you happen to know the defendant or the
Hmm.
plaintiff or anybody in what these types of cases, it's okay. It doesn't necessarily exclude you. So, the attorneys had to adjust is the bottom line because there's a small town, probably a small town mentality, and a very high likelihood that everybody knows Sawyer has 3 degrees of separation from the defendants or
Hmm.
Ahmaud Arbery. So they just had to change their MO a little bit going into this.
Love how you break it down, Candace. We'll check back in with you a little bit later for more on this case. So stick around with us,
All
okay?
right, Mike.